Morning, welcome. Tea at the ready.
Morning, everybody.
I'm Heledd. I'm a director in Greg Latcham's Solicitors, making me a solicitor. The reason I say that, it will become apparent that as a solicitor, I therefore do legal work. And a lot of the work I do is legal work, working with clients. Now, I know we've got sort of very different people here today. We've got a real mixed bag, which is great. Really, thank you so much for coming. First one we've done of these, so it's all about chatting about care. It's all about chatting about these issues that we've got with clients and how we best can accommodate that. So Ian Evans, I'll pass over to him in a moment, will introduce himself. But Ian and I have worked together now coming up 10 years, maybe, something like that.
Got to be 10 years at least.
Yeah, and really, when I say I'm a solicitor, I don't mean that, I mean that in a sort of professional sense, but also in a serious sense. It is not a flippant thing, is that actually as a solicitor, I am good at legal work. I know what I know what I don't know, and I know when to go out and ask for support and assistance. So Ian and I, as I say, have worked together a number of times, and what today we're going to do is just have a bit of a natter about how we've approached talking to each other, talking to respective clients, helping each other out, and some of the challenges we're both facing in what is an ever increasing arena of long-term care. So just shortly before I pass it on to Ian, those who know me probably heard me say this spiel before. For those who haven't, when I started practice over 15 years ago now, I was very much trained that, what we do as private client lawyers is we deal with inheritance tax and taxation, because what people do is they build up their wealth over their lifetime, and they will then drop down dead, and then we have an inheritance tax problem that then means we pass the wealth on to the next generation. What I've seen in the time I've been doing the work, let alone the sort of legislation that's come out, and I'm not going to go too much into detail about that, but we've got Mental Capacity Act and the Care Act, two big bits of law have landed in the last sort of decade, is we've seen people really going into what somebody I know says is a bit of a terminal decline. Sometimes called the twilight zone. So you've got sort of people who may have expected to drop down dead, and I've got very personal experience of this with my mother and my grandmother, where my grandmother died a couple of years ago at 91, and my mother had just retired, and she said, hang on, I've just given up a full-time job in work, and now I've got a full-time job being a carer. My mother never had to do this because her mother dropped down dead. And so she said, I was talking to my friends, all of whom are that sort of baby boomer generation, and she said, we've all suddenly found ourselves in this world of having long-term care applying to us. So with that in mind, that's where I'm coming at this, saying, this is all about actually a bit of a brave new world and a bit of an era that is a bit uncharted waters for all of us, but it could be happening to you, it could be happening to your family, it could be happening to your clients. So with further ado, over to Ian to tell you a bit about himself.
Hello, everybody. Sorry, I was just fiddling with my screen. I shouldn't be doing that, should I? I was just looking up a slide that I mentioned to Heledd earlier on. I'm Ian Evans. I know a couple of you know me. Chris has probably heard me speak so many times he's bored stiff. I'm the Head of Later Life Advice at Fiveways Financial Planning, which are based in Weston-super-Mare. I'm also the Regional Coordinator for the Society of Later Life Advisors. I normally do a quick hands up here who's heard of the Society of Later Life Advisors, but there's a lot of people without their videos on, so I couldn't see. I'm also now a newly appointed member of the advisory board of the Society of Later Life Advisors. And they are an organisation that are not for profit, and we are the financial advisor version of Solicitors for the Elderly. And the Solar People's idea is that we look at clients holistically. We specialise in looking after the elderly and vulnerable, and making sure they've got the right advice. And one of the things being a Solar advisor is we work very closely with solicitors like Heledd and other SFE solicitors around the country. and it's great working together. And Heledd and I have, well, we got on like a house on fire about 10 years ago. We met at a legal law society dinner, wasn't it? I think we first met. And we have a common goal of trying to get anyone that's ever seen me present before, my byline has always been the same thing, is get the right advice from the right person at the right time. And all too often that doesn't happen. And what Heledd and I have noticed, especially more and more over the last few years, is this wonderful word called signposting. And it's definitely a trigger to get Heledd and I quite angry, because it's signposting, and I'll come on to that a bit later on. But that's who I am. That's me in a nutshell. The one thing that I will say about solar advisors are, one of the misconceptions is A, it's expensive. It isn't. B, it's really hard. It isn't. If you know what you are about and you want to specialize in that area, you should know most of that information before you go for the accreditation. And thirdly, you become a solar advisor to earn lots of money. That's not true either, because I would say probably 70% of the work I do for free, because I like to help people get the right advice at the right time. But that's not to say they don't come back to me some point later, or a family member will come back to me at some point in the future and do business with me. Because obviously I'm not a charity, and I have got a job. But at the end of the day, I think the key point is, and Heledd is the same, is get the person to the right, in front of the right person, and the right advice when they need it. Would you agree with that, Heledd?
I absolutely would, Ian, and I think that that's a really important aspect that you often find. Often we'll all have it. It's the Friday afternoon, 5 p.m. phone call. Panic, something's gone horribly wrong. Dad's had a fall, or mum's had a diagnosis, and suddenly there's this requirement to do an awful lot more than just be a relative, and people will find themselves in that sort of like, where do I even begin? I mean, the phone calls I have are normally, so I signed a power of attorney maybe 15-20 years ago, and what is that? And so, what's the power of attorney? Right. So we then talk about the power of attorney, and they go, right, I didn't really understand that it was quite such a big deal, and the hospital's now pushing for a discharge, or there's somebody saying Dad's got to go into a care home, and I'm quite frightened. To be perfectly honest, it's quite scary. There's stuff going on, and I don't know where to begin. And I go, okay, well, let's start at the beginning. What's the right answer for Mum? What's good for her? What does she want? Well, she's worried, she's scared. Particularly if you get husband and wife. I mean, they've been married an awfully long time. They've got this sort of codependency. They've probably been ticking along okay, and then one of them gets sick, and then the whole thing starts to unravel, and then sort of this family structure that you've sort of rely on and created, suddenly the foundations are crumbling. And so what you end up having to do is sort of say, okay, well, how do we put that scaffolding back in place? How do we scaffold you, Mum, Dad, to get the right answers? So first thing I'll do is go, right, great, you've got power of attorney, let's get it out. Let's look what it says. Let's look what you can do with it. So we know about pre-2007, you had old enduring powers of attorney. They're still there. They're still in cupboards. They're still valid. Cracking for dealing with the finances. Often people who have the old enduring powers of attorney don't have the health one. And I know when the Mental Capacity Act came in, that there was a bit of skepticism, from my colleagues included, when I was working, going, well, we don't really understand the need for the health one. What's the purpose of the health one? The old EPA worked just fine, didn't it? And again, what I say is that, life doesn't stand still. Things have moved on, and actually people's understanding has moved on. So what I'm finding, and Ian and anybody else who's out there can answer this, is I'm seeing that people are saying, oh, my doctor's asked for the health LPA, the nursing homes asked for the health LPA, the doctors asked for the health LPA, and they won't talk to me without it. And so we've got a bit of a time lag with people not being not having all the requisite bits of paper. So this is one of the first conversations. If you've got both bits of paper, you've got all the bits of paper you've got to need to go and shout, to go and, you know, have the right conversations with the right people. So first thing is, let's look at what you've got as power of attorney. Second thing is, right then, what's the immediate problem that needs fixing? If mum's in hospital because she's had a stroke or hip's broken, she's at least safe, and you don't have to worry about those 3 o'clock telephone calls. What's going to happen? The worst has happened. What we now need to do is really build that roadmap going forward. So, as I say, as a lawyer, I will sit there and go, well, let's make sure that you've got your powers of attorney in place. If you haven't, let's see if we can get it. If somebody hasn't got a power of attorney and they've lost mental capacity, is there anything else we need to do or can do? So sometimes we'll end up applying to the Court of Protection. We'll then say, okay, let's look at funding. Let's look at making sure that, you know, you've talked to the hospital about NHS continuing healthcare funding. We have a cradle to grave NHS system, and if somebody's health needs are somebody's care needs are primarily health, then the NHS should be paying for it regardless of location. Now, wonderful aspirational notion, the reality is very different. But I sit there and go, yeah, but the law says that you're entitled to this. So one of the first conversations I will always have is go and ask for an assessment. The answer is probably no. The answer is pretty much guaranteed to be no, unless you're one of these really fortunate people who gets that, you know, passes go and collects £200. Then great, I'm wrong. But at least if you've got an assessment, not only have we got a line in the sand that says this is where you are as of the 1st of October, you've also then got something to challenge. And the reason this is important, and it'll tie into when I'll say, okay, I've done my bit, go and talk to your financial advisor, you know, or if you don't have one, we can introduce you to somebody about how we actually fund care going forward, because that's going to be part of it. I can clear off the legal points. I can say, do you get NHS funding? Yes or no? If not, what else is available to you? Then once we've looked at the funding available, NHS continuing healthcare funding, then funded nursing care, which you can get if you've got somebody in a registered nursing home. If you're then looking at somebody who doesn't qualify for these external funding sources, you're looking at what will then happen is somebody's going to say, well, you've got money in the bank, you just pay for it yourself. And this is where getting your scaffolding is really important. The next step is to go and have a conversation with the local authority and go, come and do a financial assessment, because I don't know what mum's got. I need you to come and do the assessment. If you do the assessment, we can then work out what money there is. So more often than not, you'll get a husband and wife, and the money will be held in various pots, and there will be pensions, and particularly the older generation, you'll have somebody who'll have a bigger pension than the other one, and the bottom line looks like there's money, but actually in whose name is it? So getting that financial assessment is really important. Once we've done the financial assessment, and I'll skip over this bit because I'll pass the bit over to Ian, is say, okay, well now you're going to be paying for care. I'm out because I'm not allowed to do financial advice. I'm a solicitor. I can count that far because I'm a solicitor. And what you need is somebody who can do this bit for you. So, Ian, talk about what you do at this point.
Thank you very much. Well, I was just going to say, just preemptive that this is the start of where Heledd comes in to start speaking to people while she's been approached by a client, is also the start as a financial advisor. Somebody will come to us, family member, an existing client, and start talking about how how they pay for care for their family member. And we always start at the same point as Heledd starts of, what are you? What's wrong with you? Have you had an assessment done? And then quite often that's where Heledd and my paths will converge, because I'll start asking questions about health and have they had an assessment, and is there any chance of NHS CHC? And then you know, that's when Heledd and I will work, and Heledd will write letters for us, and we can give examples of cases where we work together on. And just as a step before that, with NHS CHC, and we've witnessed this quite a few times, it says all over the regulatory guidance it's not palliative care, but unbelievably still quite a lot of doctors and medical professionals think it is only for palliative care. And I've heard it quite often where someone said they've been to see the doctor, or they tried to do NHS CHC, and the doctor or medical professional said, you're not ill enough, you're not dying, you won't get it. And we both know that's not what it's meant for. It's not people that are palliative, it's people that need, and their priority need is health, is health cover. Anyway, so that's my bit. So as an advisor with the money side of it, they may have had the assessment or they may not have had the assessment. We will obviously start going through their personal circumstances. If they've already gone into care, we know there's a price involved in how we cover it. Or if they're thinking of going into care, we then start to look at what they can do. So the very first thing I do, and I think most SOLA advisors will do, is ask them what benefits they're in receipt of to make sure they are in receipt of the correct benefits. So obviously you've got attendance allowance, if they're on a very low income, carers allowance, but we don't see that very often. And as Heledd said, if they're in a residential home that's registered to receive a funded nursing care contribution, have they applied for it? Are they getting it? And the simple one, and you'd be surprised at the amount of time I've seen it not done, is people already in a residential home that are on the lower rate attendance allowance because nobody's put the claim in for the higher rate attendance allowance. And the higher rate attendance allowance is not backdated. I think 3.5 years was the most I saw in a case where no one had bothered to claim it. It wasn't in the southwest, it was in the southeast. But yeah, and when they moved to the southwest, the guy came to see me as a SOLA advisor, and I went through it and I said, how long has he been in a care home for? 3.5 years. And worked it out that he needed 24-hour care because he was unsteady on his feet, and no one had ever pointed out that they could get an extra 30-odd quid a week attendance allowance. With funded nursing care contribution, as we know, the nursing home has to be registered to receive it. At the last review I looked at, only 48% of the care homes in the UK were registered to receive it. So when you say to someone, have you done this? You then have to make sure the nursing home or registered home with nursing is registered to receive it, which normally means they have to have a nurse on site 24/7. So that's a little interesting one. I don't know the full ins and outs of that, but I know there's only 48% of the care homes.
And that's a really interesting point, Ian. And I think that something, when I'm talking to clients about talking about which care home are you looking at, it's asking that question, because they'll go, oh, I found a lovely care home just around the corner. I go, is it a care home or a nursing home?
Yeah.
Oh, I don't know, what's the difference? So we'll do exactly what Ian says. And I say, you might want to find something that's got both. You can have a sort of a care wing and a nursing wing, or actually, do the both opportunities. And at this point, it's really important to look at the contract. It's really important to look at what the contract says that's being assigned. I've seen many different contracts, and some will say, if you are in receipt of registered nursing care, we will take that top slice and you still pay the flat rate. Or other care homes will go, if you pay the flat rate, but if you then need nursing care, we reduce it. Well, actually, that makes quite a difference either side, particularly if you're looking at supporting a spouse who's still at home. And I think one of the things that, I always say that where it's really valuable to get the joined up advice at this point is if you've got, particularly where you've got a husband and wife or a partnership or a co-household, because you've got a person who needs care and the person who's looking after them, so that these people don't come in isolation. And I think, Ian, perhaps it'd be a good time to sort of talk about the case we had that you talked about the other day with the NHS funding with the husband and wife. Devon,
yes. Yeah, well, the interesting thing with that was it was a case introduced to me through the SOLA website, I believe. Actually, no, it was a solicitor. Anyway, long story short, I was introduced to this case, and he was going into respite care regularly, and it was costing the wife a fortune. And she was very concerned that the money was running out, they couldn't afford care. He had quite a substantial amount of money in pensions, so the income was going, but they were living in rented accommodation and it was just costing her a fortune. So I met the husband, and he'd been diagnosed with Parkinson's, and I was sort of looking at him and thinking his need is care. He can't do a lot for himself. So I followed the route, got someone from the local authority to come and do an assessment for him. Um, Basically, the assessment was done and they made the wife go out of the house. And when the assessor made him make a cup of tea and a piece of toast, which he struggled to do, but they said you can feed and water yourself, therefore you're not eligible. At which point I got quite angry and contacted Heledd. And Heledd wrote a lovely letter to the local authority. Well, I think it was lovely. I don't think they thought it was lovely, do you? But we questioned their situation and we looked at it, and we had another assessment done. And it turns out the gentleman didn't have Parkinson's. He actually had parasupranuclear palsy, which presents very similar to Parkinson's, but the degeneration is much, much quicker. And it really does affect the motors, so you can't do things very well. And we also pointed out what happened in the assessment. And the long and short of it was, he was then admitted to a specialist home with nursing. But the story doesn't end there. So as far as we're concerned, we're thinking, oh, great, he's got NHS continuing healthcare, it's been granted, they're going to look after his needs. Literally 3 days after the letter was received saying they were going to award NHS CHC, his wife phoned me up in tears because she'd had a phone call from the nursing home to say the NHS refused to fully fund the care, saying that the bill was £1,600 a week, but they only pay £1,100 a week in these cases. And I basically pointed out to her that it's irrelevant. It's a battle between the care home now and the NHS, because the NHS is fully funded. And the NHS were trying it on, basically. So they went back to the NHS and said, no, it's £600 a week, we've got to pay for it. And they did. And the gentleman had the last 18 months of his life being looked after 24/7 in the care he, well, I'd say deserved and needed. But that wouldn't have happened if Heledd and I hadn't have collaborated, and I hadn't have known what we need to do and have someone like Heledd that can write the challenging letter to the NHS. We've also got another case in Burnham-on-Sea where we both think he should be on NHS CHC, but they're just refusing point blankly to do it because they're saying his care needs are being met at home, although it's costing them an absolute fortune. But yeah, I'm not going to go there, but having Heledd to be able to work with, and I know Robin said, is there not a need for collaboration? There is always a need for collaboration between a solicitor and IFA, but the solicitor's got to be, like Heledd, really knowledgeable in this later life arena. Which I'm going to bring on to another point now, because this literally only happened yesterday and it's quite interesting and it's in the same subject matter. I delivered a webinar last week for the Good Care group, and one of the attendees saw what I was saying and contacted me with a question about powers of attorney. And I'm sure this is something that Heledd sees quite a lot as a solicitor, and I see it a fair bit as an IFA as well. And the situation was, it had come to his attention because his elderly mother was being looked after by his wife and sister. And he was concerned that him and his wife didn't have any children to look after them. They had no issue or no offspring. And he wanted to do a power of attorney. And who could he appoint? Because everything he'd read on the web and all the documentation pushed them towards getting a family member to be the power of attorney because it was cheaper. And I explained to him that, well, no, attorneys, if you appoint a professional attorney, there are professional fees, obviously, but they will adhere to the law of looking after your best interests as much as they possibly can. And he wasn't aware, and he said all the information he'd received of the signposting was to try and ask a family member to be your attorney. And he didn't realise professional attorneys like solicitors could really adhere to your wishes. And when I explained to him that if you detail as the attorney what you want to happen, if you do need care, whether you need care at home, whether you need care in a residential home, even to the point if you go into a residential home, you can say, I want a room with a garden view. I said the attorney will do their best to do that. And if it's a legal attorney, they really will push to do that for you. So when he'd finished the conversation with me, he was much happier, thanked me for all my help. And he was then going to look at solicitors for the elderly to try and appoint an attorney to do the powers of attorney for him. But this only happened 24 hours ago. So if that's one case in isolation, there must be so many other cases around the country that's happening to, where if you get the right advice from the right person at the right time, it makes people feel an awful lot happier.
and I would echo that. I would say that, you know, when we're setting up powers of attorney, and I think, you know, the government's great at pushing powers of attorney, banks are getting better at pushing powers of attorney, people are just generally understanding that powers of attorney are important. And I will always say, you know, but they are more than just bits of paper. They are really important bits of paper. They are really powerful bits of paper. So let's make sure we really get to the bottom of what they do.
Well, the other point, Heather, sorry to cut across you there, is because this has answered a question from earlier on about discretionary fund management within a power of attorney. And Heather and I have already had this conversation a little while ago about them. The situation is, if it doesn't mention discretionary fund management, it's quite difficult to use a DFM in an investment portfolio. Now, the legal side that Heledd was coming from, well, if the attorney can't go straight to the DFM, we know that. But if they take an intermediation from a financial advice or compliance company, or you have an internal compliance company, they'll basically say no. So if you haven't got the discretionary fund management clause in, is it item 7 that you were saying, Andrew?
Yeah.
Section 7. If they haven't mentioned it, so if it's pre-2015, was it, Heledd?
Yeah. So so in September 2015, the Office of the Public Guardian came out and said, hello, we want a clause in there about discretionary fund management. Just dropped this bombshell, 2015 September. There were a number of concerns, discussions. So SFE, STEP, other people got stuck in and said, you know, hang on, we're not entirely convinced that this is quite right. You know, this seems impractical. This seems, you know, nonsensical. This seems like, you know, a very heavy-handed way of doing it. But we have a slight element of, you know, computer says no. So when I say powers of attorney aren't just documents, they are absolutely not. If you go on the government website, and if anybody's done an LPA for themselves or done it for a family member or a friend, it's actually a really easy thing to do. It's quite a nice interface. You can tap the computer, tap all the details in, and at the end of it, out churns a lovely document you can sign. Now, tucked away on the Office of Public Guardian website, which is entirely unlinked to the form filling exercise, is you should put these clauses in. Now, we have people going, well, I want to make power of attorney for my mother, is a conversation I will have with people. And I'll go, no, you've got that the wrong way around. Your mother wants to make the power of attorney for you to be attorney. Oh, so there's a lot to this. So very often, I'm sure, and I've got no doubt, I think last statistics I saw, something like 4,000 to 5,000 LPAs a month are being registered in the Office of the Public Guardian. Even if you take 50-50 health and welfare, that's an awful lot of documents being prepared. Then you've got people doing it themselves, you've got professionals doing it. So the way I approach it, just to give you some context, is I will sit down with, you know, people making the power of attorney, and I'll go, okay, power of attorney, you're giving away responsibility or potentially giving away responsibility to people who are going to be making decisions on your behalf. They're going to be making the decisions on your behalf. They should be making the decisions on their behalf with you. But there may come a point when they're making the decisions for you, and this is where mental capacity comes a bit of a grey area. It's not a fall off a cliff job. You're not fine one day and then not the next, unless you have some sort of catastrophic incident. Being in a coma would be a sort of fairly obvious example of that. But what you have then is a sort of that sort of grey area, and then you sit there and you go, right then. So now we've found your trusted people, whether that's family, whether that's friends, whether that's professionals, or a combination of all three. We need to be able to give those people all the toolkits that they need to be able to do the job properly. So absolutely, without a shadow of a doubt, powers of attorney section 7 has a discretionary fund management clause in it. I also put in clauses that say, you as my attorneys are perfectly welcome to go and get professional advice. It just gives people that sense of comfort that they can go and ask a financial advisor, a solicitor, an accountant, somebody else for professional advice. I also put in things like in the health one, you have access to my medical records with a view to, if we're going to be starting doing challenges for NHS continuing healthcare funding, having access to medical records is hugely valuable. So absolutely, these things aren't just pieces of paper. And one thing I will say with this view to collaboration, a really cracking thing to do if you're setting up powers of attorney or you're talking to people about powers of attorney, is say to them, when you're doing the power of attorney, there's a section, people to be notified. When these documents first came out, you had to do that or dispense with it in a formal fashion. OPG government changed their mind a few years ago. I always say, put in the person to be notified section who your trusted advisors already are. So if Ian sends me a client and, Mrs. Jones will put in Ian Evans, Fiveways to be notified, which means that if anybody comes to pick up the power of attorney 15 years down the line, they'll pick it up and go, who's this? I'd pick up the phone to Ian. This can be anybody. So it could be people you want to know. It could be people who are already dealing with the affairs. And as Ian said earlier on, we are in business. We are trying to do this in a fashion that, makes us money as well as doing the right thing. So for you who are looking to that next generation, continuing the relationship, it's a great way to get to know your attorneys. Your attorneys go, oh, hello, but I better speak to them. And then it's not just a isolated one-off document that you just do and stuff in the cupboard. It's something that you can really use. So I would say that, the power of attorney, absolutely, you can do it online. And by all means, all power to your elbow if that's what you're geared up towards.
Can I interject that one then? Because when Heledd says that, and I said the same thing, and I said the same thing when people want to do their own wills. Solicitors love it if you do it yourself because they make far more money sorting out the crap afterwards when it's gone wrong.
Oh, huge fun. But it's really is a great opportunity, and it's also a great opportunity, I would say, to get everybody in a room. If once you've done the sort of once you come to the point of setting up the lasting power of attorney, and Robin, I'll come on to the EPA questions at the end because that's slightly different because they are of a limited number. So what I say, so when you're doing the LPAs again, right, well, take the instructions from your client. Who is the person making the power of attorney? First of all, I need to make sure that this person has capacity. I need to make sure this person isn't being coerced. But when I'm satisfied that they're doing this off their own back, I will then, as a second tier, want to bring in the family or the attorneys and say, come on then, if you're going to be taking this job on, you better know what you're signing. And it's a fantastic opportunity to get to know the next generation. If you can bring in the financial advisor, if you can bring in the accountant, if you can bring in whoever that person's team is, it's great. And it's such an easy win for all of us.
Well, I'll add to that because we were going to bring this up anyway. And this is something I've learned over the last few years of working closely with Heledd. So as an IFA, and I know many of your experienced IFAs out there, especially if you're solid advisors, when we go and see an elderly or vulnerable client, we want as many people as we can with us. So we normally ask if they've got a family member or, as Heledd said, other attorneys, if they're in a residential home, perhaps the manager or their care provider, whoever it is. As IFAs, we want people with us, making sure that person is okay. And if they don't understand, then we may have to ask for the attorneys or whatever it is. But we always want as many people as we can with us when we meet that client or prospect. From the legal point of view, they only want to see that person on their own. So, and I've said this to quite a few IFAs now when I'm presenting over the last few years. So if you bring a solicitor to a meeting with you to someone who possibly has capacity issues or is elderly or vulnerable, don't be surprised when the solicitor looks at you as if to say, why are you still here? Because they expect to be on their own. And the reason being is because they don't want that person to be coerced. So they're of the situation whereby that person isn't being coerced. their legal, their solicitors, they will get the instruction if they can. If they can't get the instruction from that person, they'll down the capacity route. And that to me was really interesting because I'd never known that before. I've been with solicitors to do wills, and the solicitor says, can you leave now because we've got to do the will together. I accept that. But powers of attorney and everything like that, and every other situation. So any RFAs that are here in the group, and there's a few of you, don't be surprised if you do take a solicitor to meet a client. The solicitor will expect you to leave the room, and more important, they'll expect you to know you have to leave the room. If this is the sort of work you're in, you should know that's what you need to do. It's quite an important little thing, that.
Absolutely. And because what I say to people is, if there's ever a complaint or a concern when somebody is unable to speak for themselves, either because they've died or they've lost capacity, the first person they're going to come knocking on the door of is us. And I need to be able to stand there, hand on heart, and say, no, I saw them by themselves. They knew what they were doing. It's my professional opinion that they are fine. And I've had I think one of the worst cases I've had with what was blatant coercion was a family member. And I was in the office with this lady, and because she's frail, because she was struggling to walk, her daughter-in-law came with her, and my husband's working, mum's asked us to bring her in. I said, well, that's fine, by all means, come down, happy to have a general chit chat, so did a bit of the niceties and said, okay, well, that's fine, but I'd like to ask you to leave the room. And she went, no. And as she was saying no, I watched her hands get tighter and tighter and tighter on mother's hands. And I was like, I'm sorry, it sounds awful. It sounds like I'm being terribly rude. And she went, no, I am sitting here. And this poor woman, she must have been in her 90s, was staring at me and looked terrified. And this daughter was sitting there, and it was getting quite heated. And thankfully, talk about serendipity. This lady's mobile went halfway through the call, and she, I'll have to go out the room and take this. And I was able to get 2 minutes with this lady. She went, I don't want to be here. I don't want to do this. But it escalated quite quickly, and it has inevitably, with the decisions that were made, become quite contentious after the event. And I can say, well, I did my bit.
I could remember the meeting you and I were at, where the deputy was presenting to us, and he was saying the case he had where the lady that was quite voluptuous, the elderly lady that was buxom, and had the tape recorder, the family member had stuck a tape recorder,
yes.
a telephone, down her cleavage, so that they were recording the interview and trying to talk to her about what answers she would give.
Yes.
Sorry, I mean, it's still important, but this is the lengths that people will go through to try to coerce or get a family member to do that.
So look, I think we've done about 40 minutes. I think if we go through the questions and make sure we've covered those off, and then if there's any more coming in now, we can do that. So Andrew Mentz, solicitors who don't understand and ignore Section 7, I know it's very frustrating, and yes, I do come across it, and I wish I didn't. All I can say is that, if you are referring work out, just remind them, or just remind the clients, or ask the solicitors to send you a copy before it's signed. It's one of those things, I think, that, I haven't got a problem with sharing what I'm doing, because I think a spare pair of eyes is always a really good idea. So when I'm working with anybody who sent me work, I'll always say, do you mind if I share what I'm doing? So you don't have to tell people more than once. So if we're doing a roundtable discussion with a client who's got the accountant, the IFA, client and family, subject to all the things we've just said about potential undue influence and abuse, I'll say, look, are you happy for me to just share the documents, send them across, share attendance notes? And I think if somebody's got, personally, I think if somebody struggles with that sort of level of transparency, why? There might be a good reason. The client might have said deliberately, I don't want them, in which case client confidentiality, obviously. But if the client said absolutely go ahead, then just ask to share it, because it's just so much easier in the long run. But absolutely, DFM's missed more often than they ought to be. Robin's talked about when do you lose capacity? So for those who've had dealings with the old enduring powers of attorney pre-2007, on the front it says, if you feel this person is beginning to or has lost capacity, you should register it with what was the Court of Protection is now the Office of the Public Guardian. How do you assess whether that capacity is lost? It's really can be quite hard, because capacity is task specific. Somebody might understand the difference between I want a cup of tea or a cup of coffee, but haven't got absolutely no idea about how much money they've got. I had a client recently, and we still haven't worked out whether or not she lacked capacity. She's died, sadly. She was really good at counting back from 100, in sevens. She was really good at doing complicated transactions, but could not, for the life of her, tell us how much money she had. So we sort of did it in cake. We're like, how big's your cake? No, not a clue. If we said you had £10, what would you do with it? Not a clue. And it was almost a blind spot on that. So I think what you have to do when you're looking at capacity is capacity to do what? And I think if in doubt, get a capacity assessment. If there's strife in the family, if there's somebody going to come out of the woodwork who's going to be kicking up a fuss down the line saying, why did you spend mum's money on a really nice care home when you could have put her in a cheaper one and we could have had a conservatory, get a capacity assessment, because it'll just covers your back and makes things easier. So I would say that at any point, capacity assessors, historically people have gone to GPs struggle with this just because of workloads, plus also it's getting an increasingly specialist area. I work with a couple of capacity assessors who do different things. So some are great with brain injuries, some are great with dementia. Getting the right person to do a capacity assessment is absolutely vital.
Hello, can I just, there's a question that's come in. I'm not sure if she's here or she's Leah. Jacqueline from the My Care Consultant. She asked me about immediate needs annuities and has the current pandemic affected it? It hasn't. I mean, for instance, Just and I believe Fred Aviva have a COVID paragraph now that if the person affecting the immediate need annuity dies within 12 months of COVID, they will refund the premium, less any income paid, which is quite powerful. I've not had so much from personal people. It tends to be, believe it or not, professional attorneys or deputies that will be concerned over an immediate needs annuity, because A, the cost, and B, what's the likelihood of them getting the money back in the future if the person dies. So really, with the current situation is, you can do a term assurance bolted onto it anyway if they really are worried about dying too soon. But as I said, Just definitely have got a COVID guarantee, and as I believe Aviva have something similar, as so do Legal in General. But if an attorney is concerned, or family member or deputy about it, then we will get the quote from the provider, and we'll ask the question. But you can have a guarantee put on any immediate needs annuity if you want anyway. So if you're listening, Jacqueline, I hope that answers the question. If you're not, if you listen to it on the recording, I hope that answers the question.
Lovely. Robin's going to stick his head above the parapet. Where are you, Robin?
Yeah.
Hello.
Bonada. It's about EPAs, and the reason I asked the question, we've had two examples recently where, or I'll give you one example, where we've got a client who's in a nursing home who hasn't lost mental capacity, but the manager of the nursing home persuaded the daughter to register the EPA just in case. The difficulty is that the donor hasn't lost mental capacity, and in my view is nowhere near approaching losing mental capacity. The daughters, it's a separate discussion, but they want to make gifts to the grandchildren to cover school fees. We've done a lifetime cash flow, and we've demonstrated that at a level it won't jeopardise the donor's position. But I said, now you've registered the EPA, there's a presumption that your father has lost mental capacity. and you need to make an application to the Court of Protection to sanction the gifts. And they said, well, he hasn't lost mental capacity, and he said he's fine with it. And I said, I understand that, but you registered the EPA. And said, well, we did it because the nursing home told us we should. So I suppose my question is that, and because it's happened before, where we had two attorneys that were in the throes of giving £750,000 away to themselves. And I had to say to them that you need to just stop and you need to make an application to the Court of Protection. I said, but I have a suspicion it's going to fail because you're jeopardising your mother's position. So it's this issue of what does approaching loss of mental capacity actually mean in practical terms? Is it when the mother's walking down the road in a nightie on, or is it that like my father has got vascular dementia? I can have a perfectly normal conversation with him for most of the time. I would say that he has got mental capacity, but so is it? I'm not articulating this very well, but does it fall within the definition to register an EPA, say 6 or 12 months before you think the donor is going to need an attorney's support, or is it when they are very close to the point where they are going to lose mental capacity? In other words, they are putting the electric kettle on the gas stove, and there are moments when they're lucid, but they're displaying loss of cognitive ability.
Yeah. Okay. So there's quite a lot there. So yes, first of all, I agree with you that now the EPA is registered, that the flag's been raised. This person lacks capacity, because otherwise, why would you register it?
Yeah.
Which, as an aside, it just goes to show, doesn't it, how much the man down the pub gets asked questions before we do as professionals. Yeah. But so I would say that at what point? So under the old EPA regime, the EPA could be used immediately without registration. So you could and can still act as agent. So the example I tend to use is, if I've gone on a six month round the world cruise, and I've given you, Robin, power of attorney, and I've told you can sign papers to buy and sell my house, then I've authorised you to do that. Anybody who's got any sense would go and look behind the power of attorney and ask, Heledd, you're on the round the world cruise, are you happy? And I'll go, yeah, just let him crack on. If you've got somebody whose capacity is declining or wavering, and the Mental Capacity Act says it's task specific. So again, the example I've always used when suggesting whether or not to register enduring powers of attorney is say, okay, if your parent or your vulnerable donor was doorstepped and sold £20,000 worth of double glazing, if the power of attorney isn't registered, then it's on them. They have to pay it. If they've been doorstepped and sold £20,000 worth of double glazing and the power of attorney's been registered, you're going to have a far better chance of saying, well, this person was vulnerable and should never have been allowed to sign the paperwork. So I think it's probably how much control do they have over how much money. You're not going to stop somebody sort of going to the shop and spending sort of, money on a newspaper and sort of packing a bowl of sweets if that's important to them, but actually leaving them in control of a multi-million-pound portfolio might not be sensible. And in your analogy, yeah, your attorneys, sorry, you've registered it, off you go, get the court protection approval.
Okay, so just so I'm clear then, approaching loss of mental capacity doesn't mean it doesn't fit the situation where the donor has got full mental capacity, and this is just in case something happens in the future. It's when the person is starting to display a loss of cognitive ability, and that's obviously a big grey area. It's a subjective judgment, isn't it?
It's massively grey area, and I think Jeanette's just made a really good point. It's about getting a formal mental capacity to clarify, does he or does he not have capacity? Capacity to do what? It sounds like the care home managers conflated the lasting power of attorney, which cannot be used until it's registered, with the old enduring, which can be. And again, a capacity assessment at this point is going to really clarify what that point is. So yeah, Jeanette, absolutely spot on. Get a capacity assessment. And does he have capacity to make gifts? Yes, then you've got something to fall back on. He doesn't have capacity to make gifts. Court protection approval. Should the power of attorney be registered? No, then get it deregistered.
Okay, thank you.
That's okay. Chris O'Conness. Any more questions? Have we clarified? I think we touched on the Section 7 bit quite a lot. Anybody?
I was just going to say, because Seb said about why don't we use advisory portfolios? I agree with you, Seb, but the problem is sometimes there's existing portfolios that are in DFMs, and then all of a sudden the person loses capacity, the power of attorney is starting to be used, and then you suddenly spot the problem. And that's quite interesting to discuss afterwards. But that's what I'm going to say on it. Just before we finish off, this area of work for the elderly and vulnerable is going to get bigger and bigger and bigger, and there is plenty of work to go around for those people that are adequately trained and know they want to do it. I'm just going to share a quick slide. If this works, I'd be quite impressed with myself. Just to show you some figures. It's a couple of years old now, but the figures are still right because they haven't really updated them. Where is my slide? There we are.
Oh, fancy.
So there you go with your figures, okay? So 850,000 people, and they believe that's going to increase by 1 million over 2025. I think that second point is interesting. 225,000 people, or 1 every 3 minutes, will be diagnosed with dementia or Alzheimer's. That's quite scary numbers. And the last one is unpaid carers save the economy over 11 billion a year. But just going back to what we were saying is, Heledd and I love to do the work, but there is probably so much to go around that we probably couldn't cope with all of it. So my advice is, and Heled's advice is the same: find the right solicitor, find the right IFA to be able to give that person the right advice at the right time. Hey!
Magic.
All right. Now I've got to work out how to unshare my screen.
Yeah. Go on then.
I don't know how to do that bit. Oh, I'll find it in a minute. I don't know how to do that bit.
You just click the.
I've got it now. Click the button. Yeah, I knew. I can get it there.
Magic.
Okay.
So, I mean, what I would say is I'm always open to being asked questions. Those who've already picked up the phone and picked my brains will know this, because ultimately we're all in this together. We're all in. If you're in this type of work, you've got people and you want to be doing the right job for them and you want to be doing it properly. So if I can answer your question in 20 seconds, then I've made your day better and somebody's got the right advice. I know, thank you to everybody who has been on the receiving end of me going, can I just check this, because I don't really understand. And so it's collaboration. It is about, I think Ian's phrase, right person, right place, right time, is absolutely right. We're not gonna we're not going to please everybody, and clients, God love them, have their own opinions on what's right and what's not right. And so the best we can do is collaborate, work together. As Ian says, this is a big area. So really hope that this has been interesting. We'd love feedback. We'd love questions. The plan is to do a series of these. So if anybody wants to be, have a bit of a get stuck in with me on care questions, then I would be delighted to run this. I think I learn loads, and I'm every day is a school day, and so anything like that. So and yeah, happy to be pick up the phone, drop me an email, then we can go from there. So if there are no more questions, thank you very much everybody for coming today, and I hope you got your caffeine fix. And thank you, Ian.
Thank you. No, thank you, everybody. I hope we didn't bore you too much.
Bye.
We're going to stay on